uh, an advocate who himself, along with Mr. Prem Menon, are doing Prem Raj Menon are doing a lot of webinars and which have created a lot of knowledge sharing on their platform. So we thought that why not ask a person that is Shyam Padman to give the insights of a topic that is cyber defamation law and procedure, because this is one of the topics which has started, I can say, creating its own space within the legal fraternity and otherwise. And without taking much time, because he needs no introduction as such, because once you are doing a lot of webinars and you are a key resource person, so people invariably know. And we thought that the best way out to have the insights and the of the topic and introduction through Mr. S.K. Premraj Menon, who is himself doing a lot of webinars along with Mr. Shyam Padman. So without taking much time, I will request Mr. Prem to set the webinar into motion, and thereafter Shyam will take over the issue and give us the insights of the entire topic. Over to you, Prem.
Well, thank you so much, Vikas. Today I have been caught off the guard. Actually, Justice Abraham Matthew was supposed to introduce the topic, and just 2 minutes back, Vikas ji told me that I have to introduce the topic. I know nothing about cyber defamation. Now, whatever that be. Now, regarding this cyber defamation, the growth and development of technology that has rather brought a very drastic or a sea change in the world. Now, as we know, the internet itself has made things easier for all of us through various social media sites. Many networking sites are there, whether it is communication, access to information, everything has just become like a piece of cake for each and everyone. And these facilities that may sometimes, it may lead to misuse also. As a users, they can publish and disseminate the information through these social networking sites. And defamation, of course, has by now become a subject matter of concern. With the rise of the so-called trends of sharing or posting information or pictures or videos on everything on the social networking sites and commenting on them, it has increased what we call is the risk of cyber defamation. And this particular term that basically means publishing of false, frivolous, fictitious statements about an individual in the cyberspace that can rather injure or demean or debase the reputation and character of that individual. In India, defamation it can be contemplated both on the civil as well as on the criminal side, and thus you have the legal remedies either under the IPC or you are having under the civil laws which are prevalent. And it can be by two types of defamation, which I need not even stress: libel and slander. And the cyber defamation, it has by now it has brought a kind of revolution in the Indian sphere. Not only in the Indian sphere, of course, right now we are dealing with Indian laws, so that's why I refer to the Indian sphere. Across the globe, I would say. And we are also running several risks as digital platforms. They are all prone to be exploited by unscrupulous internet users in the name of freedom of speech and expression. And this has led to numerous cases of cyber defamation. As we know, the first law which comes is in Germany during 1970. And of course, we had Section 66A, which was struck down in Shreya Singh's case by the Apex Court. And of late, we have in 2020, we have the case of Google, which says about the role of intermediaries also in the cyberspace. I mean, for these kind of offenses. Now, to carry on with the topic, you have a very good speaker, Advocate Shyam Padman, who was a senior in my senior's office. Actually, he was my senior when we were practicing together. And he is an expert in this particular field. And he himself has been running the show on other platforms also, where we have, I think we have done with this topic also, not to the fullest extent, but still somewhere here and there, tips and bits here and there. So he's a wonderful speaker, and I don't want to stand in the way of the speaker and the participants. So I just set the roll to ball. The ball to roll. And Shyamendra, please, it's all yours now.
Thank you, Prem, for the kind words, and thank you, Vikas, for the opportunity. Today, let it not be taken that I am here to impose my wisdom on you, or it should not be a monologue. Is my first submission, in the sense like I'll just share my thoughts, and let us have an interactive session also. Towards the end, and all of us can participate. There is no question of I just lead the subject, and let us see what happens. If I have got a right to marry, does that mean that every female I see should marry me? She also has got a say or a volition to say no, or maybe she would have better choices. She definitely will have better choices. Likewise, freedom of speech and expression is also any freedom, any right has got reasonable restrictions. Now, if at all in my presentation, you find any similarity between the current controversy going on around with contempt of court, it is just incidental or by chance, I would say, and not intentional, because defamation is supposed to protect people's reputation from unfair attack. But in practice, its main effect is to hinder free speech, protect powerful men from scrutiny. So in this background, I have divided my presentation into 4 categories. Number 1 is awareness, basic awareness. I'm sure that all of you are aware, but still let us together run through what exactly defamation and the basic ingredients and what the definitions are, which would be more or less like a bookish one, but still an understanding and an awareness of what exactly is defamation, the concept of defamation, what exactly are the restrictions, or what exactly are the exceptions. It's just not confined to section 499 and 500. And if you have to say that, we may have to look into article 19(2) of the constitution as well, because reasonable restrictions include defamation also in that. Then we'll touch upon avoidance, and then management of the situation, and finally we'll conclude the session with some, I'd say, I'll sum up like that. So it is awareness, avoidance, and management. To start off, I would just let us see what exactly is defamation. So let us go to the first principles. So before I start, I would like to even subdivide this category of awareness into 2 stages. It is just like AD and PC, prior to Information Technology Act and later to Information Technology Act. There, I'll start off by saying that had there been no Information Technology Act, is it that there was no cyber offenses or cyber crimes committed? Or was the existing legal dispensation machinery sufficient? Or whether the courts could have taken cognizance or adjudicated these sort of situations? So for that, I would first refer to one decision that is very interesting, in the sense like all of us are aware about section 138 of Negotiable Instruments Act, wherein if a check is dishonored or returned as unpaid, then a notice has to be issued. So dishonor of check as such is not an offense. It is only if the amount covered by the check is not paid, in spite of a notice being given, where the offense starts. So if you read section 138 as it stood, I am talking about the pre-amendment or the earlier stage when there was no delay, condonation, etc., wherein every lawyer was so anxious about the dates, because upon dishonor of a check, I'm sure that those who practiced at that point of time would be very well aware of the way we used to count, even using the calendar, to see whether the 15 days is over, the 30 days is over, and whether the case itself would lie. So in a particular case from Kerala, notice was sent through fax. A contention was raised before the first court and the second court, etc., that notice ought to have been sent by registered post acknowledgement due, otherwise the notice is bad. So one of the ingredients goes. The case also, the prosecution also fails. You can't sustain a case. It went up to the Supreme Court. The bench headed by Justice K.T. Thomas, after appreciating the entire thing, held. I'll just take that. Yeah. That is in AER 1999 Supreme Court 1609. versus SIL Import USA versus Mrs. Exim 8 Silk Exporters Bangalore. AR 1999, Supreme Court 1609. The court held that where is it stated in the Negotiable Instrument Act that notice need be given through registered post acknowledgement due? Why do you say that notice should be like that? It only says that you should intimate the drawer of the check that the amount covered by the check has not been able to be realized because there was no sufficient funds or whatever, for whatever reason the check has been dishonored and returned. The court held, while interpreting a statute, during statutory interpretation, allowances for any relevant changes that have occurred since the act's passing in law, social conditions, technology, the meaning of the word and other matters should be used while interpreting a statute. So when the Act 138 came into force, maybe there was only registered post acknowledgement due, but it was technology neutral. It did not say anything about it ought to be in such and such form or in another manner. So the court held that the issuance of check, and luckily in that matter, issuance, receipt, etc. of the fax message was not disputed. It only said that it was not in the proper form. And the court should use interpretative process to the fullest extent permissible by the enactment. Likewise, in 1973, AR 1973, Supreme Court 157, R.M. Malkani versus State of Maharashtra. The Supreme Court made it clear that electronically recorded conversation is admissible in evidence if the conversation is relevant to the matter in issue and the voice is identified and the accuracy of the recorded conversation is proved by eliminating the possibility of erasure, addition, or manipulation. Supreme Court further held that a contemporaneous electronic record of a relevant conversation is a relevant fact comparable to a photograph of a relevant incident and is admissible in evidence under Section 8 of the Act. Then Ram Singh and others versus Colonel Ram Singh, 1985 Supplemental SEC 611, 611, 1985 Supplemental SEC 611. A three-judge bench relying on the English judgments of R versus Mushkaq Ali, that is 1965 to All England Reporter 464, and R versus Robson, that is 1972 to All England Reporter 699, held that it will be wrong to deny to law of evidence advantages to be gained by new techniques and new devices, provided the accuracy of the recording can be proved. So, in effect, the existing law prefixed with E would be what we can say as the cyber law. Now, after the coming of the Information Technology Act, we had a couple of sections coming in, with which we'll deal first. But before that, let us see what exactly is the concept of defamation, not just under Section 499 and 500 of the just give me a second, I'll just plug in because the power is less. Yes. Let us see. I mean, it has been elaborately dealt with by the Supreme Court in Subramania Swamy case, that is 2016, Volume 7, SEC 221. Then just a couple of excerpts from some literature would throw light on that. Fundamental right of freedom of speech does not confer on citizens right to speak or publish irresponsibly. Then fundamental right of freedom of speech comes with reasonable restrictions. Why? Because in an organized society, the rights have to be recognized with its duties and responsibilities towards the society, public order, decency, morality, and such other things must be safeguarded. Then again, in Subramania Swamy case versus Union of India, that is which I refer to 2016-7 SEC 221, at paragraph 120, be that as it may, the aforesaid authorities clearly lay down that freedom of speech and expression is a highly treasured value under the Constitution, and voice of dissent or disagreement has to be respected and regarded and not to be scuttled as unpalatable criticism. Emphasis has been laid on the fact that dissent and discordant expressions are to be treated as viewpoints with objectivity, and such expression of views and ideas being necessary for growth of democracy are to be jealously protected. Notwithstanding the expansive and sweeping and ambit of freedom of speech, as all rights, right of freedom of speech and expression is not absolute, it is subject to reasonable restrictions. So what is reasonable restrictions has been dealt with by the Supreme Court in Chindaman Rao versus State of MP. That is AR 1951 Supreme Court 118. AR 1951 Supreme Court 118. Reasonable restrictions connote that the limitation imposed on a person in enjoyment of the right should not be arbitrary or of an excessive nature beyond what is required in the interest of the public. The word reasonable implies intelligent care and deliberation. That is the choice of a course which reason dictates. Legislation which arbitrarily or excessively invades the right cannot be said to contain the quality of reasonableness, and unless it strikes a proper balance between the freedom guaranteed under Article 19(1)(g) and the social control permitted by Clause 6 of Article 19, it must be held to be wanting in that quality. So it is Article 19(1)(a). Again, I would also rely on one more paragraph, that is, freedom of speech can be restricted only in the interest of the security of the state, friendly relations with foreign state, public order, decency or morality, on relation to contempt of court, defamation or incitement. That is Article 19(2). So defamation is one of the grounds by which or basing on which there can be a reasonable restriction on your freedom of speech and expression. Then again, if a law directly affecting it is challenged, it is no answer that the restrictions enacted by it are justifiable under clauses 3 to 6. For the scheme of Article 19 is to enumerate different freedoms separately and then to specify the extent of restrictions to which they may be subjected and the objects for securing which this should be done. A citizen is entitled to enjoy each and every one of the freedoms together, and clause 1 does not prefer one freedom to another. That is the plain meaning of this clause. It follows from this that the state cannot make a law which directly restricts one freedom from another. Then again, in 1971, 1975, SCC 11, that is Acharya Maharishi Narendra Prasad Ji, Anand Prasad Ji Maharaj versus State of Gujarat. That is 1975, SCC 11. A particular fundamental right cannot exist in isolation in a watertight compartment. One fundamental right of a person may have to coexist in harmony with the exercise of another. It is just like saying that if I got a freedom, equal freedom is available to you and everyone. If my freedom is to be respected, I have to respect the other's freedom, then only we can coexist. This is the simple logic behind this, sir. Then again, in 1991, Supplemental 1 SCC, page 600, the Delhi Transport Corporation versus DTC Mazdoor Congress, 1991, Supplemental 1 SCC 600. Articles relating to fundamental rights are all parts of an integrated scheme in the Constitution, and their waters must mix to constitute that grand flow of unimpeded and impartial justice, social, economic, and political, and of equality of status and opportunity, which imply absence of unreasonable or unfair discrimination between individuals, groups, or classes. So, again, one more decision which I may also straight away come to is St. Stephen's College versus University of Delhi. That is 1992, 1 SCC 558. St. Stephen's College versus University of Delhi, 1992, Volume 1, SCC 558. While emphasizing the need for balancing the fundamental rights, observed that it is necessary to mediate between Article 29(2) and Article 31. Between letter and spirit of these articles, between traditions of the past and the convenience of the present, between society's need for stability and its need for change. Thus, the freedom of speech and expression is not unconditional, but it is subject to a number of restrictions, and these restrictions find mention in the Constitution itself. Article 19(1)(a) of the Constitution of India provides freedom of speech and expression, and Article 19(2) imposes reasonable restrictions on the existence of such rights as 19(2) specifically and categorically mentions defamation. So I'm laying the foundation that we got not just section 499, 500, etc., but the constitutional mandate also that your freedom of speech and expression is circumscribed by the laws of defamation. Whatever criticism you may say about defamation, howsoever instances could be brought out of misuse of it, unless and until you are the victim, It may be very easy to lecture on freedom of free speech, expression, etc. Then again, reasonable restriction connotes that the limitation imposed on a person in enjoyment of the right should not be arbitrary or an excessive nature beyond what is required in the interest of public. Then just one word regarding constitutional scheme 19.2, which I already read, that is in relation to contempt of court, then defamation or incitement. And as I started off my presentation, here also both comes together, contempt of court as well as defamation in Article 19.2. Then let us see the different definitions given of defamation. Winfield would say, defamation is the publication of statement which tends to lower a person in the estimation of right-thinking members of society generally, or which tends to make them shun or avoid that person. It is libel if the statement be in permanent form, and slander if it consists in significant words or gestures. Then again, Salmond would say, a defamatory statement is one which has a tendency to injure the reputation of the person to whom it refers, which tends, that is to say, to lower him in the estimation of right-thinking members of society generally, and in particular to cause him to be regarded with feelings of hatred, contempt, ridicule, fear, dislike, or disesteem. The statement is judged by the standard of an ordinary right-thinking member of the society. That is the benchmark. If I am oversensitive, or if I would say I am annoyed by a statement, but the court would weigh, the benchmark would be, would it amount to a defamatory statement if you stand in the shoes of an ordinary right-thinking member of society? Then Halsbury's Laws of England would say defamatory statement. A defamatory statement is a statement which tends to lower a person in the estimation of right-thinking members of the society generally, or to cause him to be shunned or avoided, or to expose him to hatred, contempt, or ridicule, or to convey an imputation on him, disparaging or injurious to him in his office, profession, calling, trade, or business. Then I would also, in Chambers' 20th Dictionary, defamation, it has been stated, the wrong of defamation. Defamation consists in the publication, that is, according to Salmond again, quoting Chambers' 20th Dictionary, then again, the wrong of defamation consists in the publication of a false and defamatory statement concerning another person without lawful justification. The wrong has always been regarded as one in which the court should have the advantage of the personal presence of the parties if justice is to be done. Hence, not only does an action for defamation not survive for or against the estate of a deceased person, but a statement about a deceased person is not actionable at the suit or of his relative. But that we got exceptions. I shall come to that decision. Even a statement made against a dead person, if it injures the reputation of persons who are alive, is actionable. So there are a lot of definitions that has been given. So I'll once again come to one of the cases of Manisha Koirala versus Shashilal Nair. That is 2002 SEC Online, Bombay 827. The tests that has been carved out in Manisha Koirala's case are: number one, a statement concerning any person which exposes him to hatred, ridicule, or contempt, or which causes him to be shunned or avoided, or which has a tendency to injure him in his office, professional, or trade. Number two, a false statement about a man to his discredit. Number three, would the words tend to lower the plaintiff in the estimation of right-thinking members of society generally? So this, I would say, are a few of the definitions that I could lay my hands on. Then I would, regarding the reputation, comments have been made by the Supreme Court in Vishwanath Agarwal versus Sarala Vishwanath Agarwal. That is reported in 2012, volume 7, SEC 288, wherein it is held at paragraph 55. Reputation, which is not only the salt of life, but also the purest treasure and the most precious perfume of life. It is extremely delicate and a cherished value this side of the grave. It is revenue generator for the present as well as for posterity. The way in which the Apex Code evaluates, understands, and deals with reputation. Then again in Kiran Bedi case, Kiran Bedi versus Committee of Inquiry, that is 1989, Volume 1 SEC 494. In it, the observations in DF Marion versus Davis, that is 55 ALR 171, 1927 decision. It held in paragraph 25, the right to the enjoyment of a private reputation unassailed by malicious slander is of ancient origin and is necessary to human society. A good reputation is an element of personal security and is protected by the Constitution equally with the right to the enjoyment of life, liberty, and property. In Mahmood Nayyar Azam was a state of Chhattisgarh, that is reported in 2012, Volume 8, SEC, page 11, Supreme Court held, the reverence of life is inseparably associated with the dignity of a human being who is basically divine, not servile. A human personality is endowed with potential infinity and it blossoms with dignity is sustained, and dignity is sustained. The sustenance of such dignity has to be the superlative concern of every sensitive soul. The essence of dignity can never be treated as a momentary spark of light or, for that matter, a brief candle or a hollow bubble. The spark of life gets more resplendent when the man is treated with dignity sans humiliation, for every man is expected to lead an honorable life, which is a splendid gift of creative intelligence. When a dent is created in the reputation, humanism is paralyzed. Why I am indulging in this is because in this era, and when it is fashionable to advocate free speech or freedom of speech and absolute disappearance of all sort of restrictions on expression, these are thoughts which are to be there in our mind while dealing with the topic. Then I'll just one more decision and I'll stop on this one. That is Umesh Kumar versus State of Andhra Pradesh, 2013 10 SEC 591, 2013 Volume 10 SEC 591. Personal rights of a human being include the right of reputation. A good reputation is an element of personal security and is protected by the Constitution equally with the right to the enjoyment of life, liberty, and property. Therefore, it has been held to be a necessary element in regard to right of life, right to life of a citizen under Article 21 of the Constitution. Now, that has been equated as a fundamental right by stretching, or rather reading into Article 21. Life means not mere animal existence. It means to live with human dignity, and human dignity encompasses and takes in reputation as well. So if you injure the reputation of a person, you are violating the fundamental right of that person. To that extent, the apex code goes in Umesh Kumar versus State of Andhra Pradesh, 2013 10 SEC 591. The International Covenant on Civil and Political Rights 1966 recognizes the right to have opinions and the right to freedom of expression under Article 19 is subject to the right of reputation of others. This is how the Supreme Court concludes on that point. So in this background, let us analyze the topic in hand. So it is an invasion of privacy. It is an invasion or an infringement of the fundamental rights, and it is something that is legally impermissible and socially abhorring. So indulgence in that would be at your own risk and peril. Now let us see how we go about it. Sections 499 and 500. I don't want to read out the portion because I am definite that all of you would have gone through it obtained number of times, the exceptions, explanations, everything. But just a short recap in the sense, like I'd say that the libel and slander, of course, Prem Raj has already touched on that. I don't want to go on to that. But still, if you are to distinguish between libel and slander, libel is addressed to the eyes while slander to the ear. The very easy way of understanding. In English criminal law, only libel has been recognized as an offense. Slander is no offense. In Indian law, both are criminal offenses under Section 499 and 500 of Indian Penal Code. Under law of torts, slander is actionable and libel is actionable per se. If any of you are interested in a couple of decisions regarding this, I can just leave it behind. I'm not going into it, which is illuminative. One is DP Chowdhury versus Kumari Manjulata, AR 1997, Rajasthan 170. And regarding the essentials of defamation, number one is the statement should be defamatory. Then Innuendo also, of course, the statement may be prima facie innocent, but once you can definitely relate to the person, it can be said to be an innuendo, and it is as good as or as worse as having a direct statement defaming somebody. Then it should refer to the plaintiff, of course. There again, Delhi decision is there. It should be, there should be publication, there should be circulation, etc. Now, let us just see the broad spectrum. That is, defamation can be against two categories. Number one category is individuals, the other is establishments. Individuals, there is a distinction possible between public authorities or public figures and ordinary individuals. That distinction can be drawn by the celebrated case, as you all know, the New York Times Company versus Sullivan. That is 376 US 254, 1964 decision. That has been important. That is what exactly is required is there should be malice. That is important in India in R. Rajagopal versus State of Madras. The distinction between if you are a public authority or a public figure, your right to have the privacy or to be protected against criticism, etc., is limited vis-a-vis an ordinary citizen otherwise. So that I'll just elucidate a bit on that point and move forward. So as I said, defamation can be twofold. One is regarding individuals and other is regarding establishments. Establishments could be government and private. Individuals can be celebrities, politicians, public figures, and the other is ordinary individual. A recent decision of the Madras High Court, if you can just go through that, really a wonderful decision of Justice G.R. Swaminathan. That decision is Grievance Redressal Officer, Economic Times Internet Limited versus VV Minerals Private Limited. The citation would be 2023 Law Weekly 430. 2020, that's 2020, Volume 3, LW 430. Grievance Redressal Officer, Economic Times Internet Limited versus VV Minerals Private Limited. In that decision, it is held that it goes into the root of the entire matter in the sense like R. Rajagopal versus State of Madras has been examined. The New York Times versus Sullivan. The rule of Sullivan is based on the recognition that if free speech and especially journalistic speech is to survive, it must have breathing space. In other words, mere inaccuracies will not subject the writer to defamation unless it is shown that the writer either knew that they were making false statements or made with such reckless disregard for whether they were true or not. The law of civil defamation became more speech protective than criminal defamation, a reversal of the traditional rule that criminal proceedings need to come with more procedural safeguards. Now, in paragraph 14, he would say, there can always be a margin of error. The permissible width of the margin will depend on the facts and circumstances of each case. The media can avail this defense, whether the complainant is a public official or a private entity. Mere inaccuracies in reporting cannot justify initiation of prosecution. Then, in that case, it was a 482 application to quash the proceedings. There, the Madras High Court held that a summary examination could be done. So it held like this. If a summary examination of the materials produced by the accused can bring their case within one of the exceptions, I can give relief to the petitioner here itself instead of making them undergo the ordeal of trial. Such an activist role will have to be played by the higher judiciary because it is a matter of record that criminal defamation proceedings have become a tool of intimidation. So, like I said, the very purpose of having the concept of defamation has now become a tool in the hands of the unscrupulous to perpetrate injustice. Proceedings have become a tool of intimidation, and before corporate bodies and powerful politicians whose pockets are tunnel deep and whose hands are long, even media houses having good resources have capitulated. Here, I'll to conclude what in this aspect is that the judgment holds that the Sullivan rule of actual malice applies to criminal defamation and in particular to exceptions 2 and 3. Thus, mere factual errors in reports or issues of public importance cannot justify criminal prosecution. And B, that in the light of the constitutional guarantee of free speech, the High Court acting under Section 482 CRPC is empowered to conduct a summary examination and assess whether an accused falls within the Sullivan rule in a particular case or not, and to quash the case if they do. So that is regarding that distinction between. Now, what is the change that has been brought about by the Information Technology Act? For one thing, sections 1, 2, section 1, subclause 2, and section 75 assumes importance because it becomes transnational. For offenses committed outside India, even power is granted or authority is granted to take action. We shall come to Baba Ramdev's recent universal takedown order, etc., wherein this has been exercised. So if you analyze the Information Technology Act, first you will have to see section 1, 2. If you are having the Bar Act, kindly go through, or I'll just show you. Short title extent is 1 and subclause 2. It shall extend to the whole of India and save as otherwise provided in the Act. It applies also to an offence or contravention thereunder committed outside India by any person. Then directly let us go to section 75. 75 states, Act to apply for offences or contravention committed outside India. Subject to the provisions of subsection 2, the provisions of this Act shall apply also to any offence or contravention committed outside India by any person irrespective of his nationality. Subclause 2, for the purposes of subsection 1, this Act shall apply to an offence or contravention committed outside India by any person if the act or conduct constituting the offence or contravention involves a computer, computer system or computer network located in India. So it is transnational. These two provisions will have to be kept in mind. Then also there are chapter 9 and 11. Section 43 onwards deals with damages, and chapter 11, section 66, etc., comes under the punishments. Here, I would also request your attention to section 84B. 84B and 84C. 84B is abetment. Punishment for abetment of offense. So even if you are abetting under the Information Technology Act, punishment for abetment offense is provided under 84B and punishment for attempt to commit offenses in 84C. These were all introduced by Act 10 of 2009. It was not there in the original Act of 2000. It was introduced by way of amendment in with effect from 27/10/2009. Then section 85 also is interesting because it relates to offences by companies, where a person committing a contravention of any of the provisions of this Act or any rule, direction or other order made thereunder is a company. Every person who at the time of the contravention was committed was in charge of and was responsible to the company for the conduct of business of the company, as well as the company shall be guilty of the contravention and shall be liable to be proceeded against and punished accordingly. Here, one another provision that has to be kept in mind is this is just like section 3 of the old Consumer Protection Act and the current, I think, 100 of the Consumer Protection. This act is in addition to and not in derogation to. A similar provision you can find in section 77. No compensation awarded, penalty imposed, or confiscation made under this act shall prevent the award of compensation or imposition of any other penalty or punishment under any other law for the time being in force. Then chapter 12 is of importance. That is regarding intermediaries. I shall come to that in a second. So, but one important aspect is that it was only section 66A which could have been directly invoked to deal with defamation. But it has been struck down as unconstitutional in, like Prem also mentioned that Shreya Segal's case, that is AER 2015 Supreme Court 1523. I'm sure that all of you are aware of that decision. AER 2015 Supreme Court 1523. The funniest part is that even if you take the latest edition of the BAR Act, you will find 66A still printed because that has not been removed from the statute. It has not been amended or substituted. So that is why the Supreme Court has to recently warn the police that if you arrest somebody under 66A, which has already been struck down, you will be held in contempt. Because any person who takes the text and sees 66A still is there. But it has already been struck down by the Apex Court in AER 2015 Supreme Court 1523. But till date, no substitute or no amendment has been made. So now let us come directly as far as the awareness aspect of this is concerned to chapter 12. Chapter 12 deals with intermediaries. Two aspects I want to mention about intermediaries. That is the classic case dealing with the entire gamut of intermediaries, as you all know, is Google India Private Limited versus Vaishakha Industries and others, reported in AER 2020 Supreme Court 350, or rather 2020 Volume 4 SEC 162. Only few lines for your reference. Wherein, as you all know, the earlier as it stood, the section 79 as it stood earlier was like this. That is, for the removal of doubts, it is hereby declared that no person providing any service as a network service provider shall be liable under this act, rule or regulations made thereunder for any third-party information or data made available by him if he proves that the offense of or contravention was committed without his knowledge, or that he had exercised due diligence to prevent the commission of such offense or contravention. Explanation says network services provider means an intermediary. Third-party information means an information dealt with by a network provider. So earlier section 69, it was a safe harbor provision. Internet intermediaries didn't have any problem because they need only show that due diligence was shown. Now, the takedown provision comes under section 79(3) of the amended. The amendment was carried out as per Act 10 of 2009, and the new provision reads like this: exemption from liability of intermediary in certain cases. All these things came because section 79 itself was introduced because of the Basi.com case. That is Avinish Bajaj versus State of National NCT of Delhi, 116 2005 DLT 427, wherein for offences committed by persons who are using the platform, the Basi.com CEO was arrested. Now, section 79 says intermediaries not to be liable in certain cases, notwithstanding anything contained in any law for the time being in force, but subject to the provisions of subsections 2 and 3. An intermediary shall not be liable for any third-party information, data, or communication link made available or hosted by him. So, what is 2 and 3? 2 is the provision of subsection shall apply if the function of the intermediary is limited to providing access to a communication system. So, he is only a provider. He just provides the platform. Then the intermediary does not, he should not do certain things. Number 1, initiate the transmission. Number 2, select the receiver of the transmission. Select or modify the information contained in the transmission. The intermediary observes due diligence while discharging his duties under this act, and also observes such other guidelines as the central government may prescribe in this behalf. The provision of subsection 1 shall not apply. This is most important, because the provisions of subsection 1 of absolute immunity shall not apply if the intermediary has conspired or abetted or aided or induced, whether by threats or promise or otherwise, in the commission of the unlawful act. Number 1. Number 2, that is very, very important, because this is where we as a normal individual can have a obnoxious or undesirable post or something or a website taken down. That is, upon receiving actual knowledge or on being notified by the appropriate government or its agency that any information, data, or communication link residing in or connected to a computer resource controlled by the intermediary is being used to commit the unlawful act, the intermediary fails to expeditiously remove or disable access to that material on that resource without vitiating the evidence in any manner. Here, the Supreme Court goes to the extent of saying, that's very interesting to note, that if they don't remove, they might even be held liable for publication. The terminology used is, there may be publication within the meaning of section 499 of the IPC, even in the case of an internet operator, if having the power and the right and ability to remove a matter, upon being called upon to do so, there is a refusal to do so. So not only a positive act, but an omission or an inaction also may hold the intermediary liable. Then paragraph 150 and 151 of this decision, Google India Private Limited, may be also seen. I'm not going to read out the entire thing that I have already given the citation. That's AAR 2020 Supreme Court 350 and or rather 2020 Volume 4 SEC 162. The entire decision is a wonderful decision, but this paragraph, so when does what is it that is meant by an intimation, or how you can say that the intermediary did not act? Here it categorically says that it is not you sending notice. It is an adjudication by a competent civil court and then an order being. That is where it said that as delay may occur, even interim orders can be granted. And that has to be complied with. The problem arises in this way, however, it is while considering a challenge to section 79 of the Act, after it has been substituted with effect from 27/10/2009, and considering the rules made in the year 2011, and a challenge to the same also, that in Shreya Singhal, the provisions were read down to mean that section 79(3)(b) of the Act, very, very important. 79(3)(b) of the Act and Rule 3(4) of the rules would require an internet service operator to take down third-party information, not on mere knowledge of objection to its continuance, but after there has been an impartial adjudication, as it were, by a court. So there should be an impartial adjudication, and then it has to be communicated. To focus more on the problem, it must be pointed out that in the facts of this case, the acts constituting the alleged offense under section 499 of the Indian Penal Code were done not in section 79 and its substitution, etc. The rules were enacted in the year 2011. I shall come to when we deal with management regarding that, but this decision may be kept in mind. That is Google India Private Limited versus Vaishakha Industries. Yes. Now that the basics of what exactly would constitute defamation and defamatory remarks, let us move on to the next aspect of avoidance. The avoidance can only be done if we have, that is not strictly a legal thing. It is evolution of a behavioral protocol in internet. We don't have any behavioral protocol. We cannot expect laws to be there. Respecting elders or standing up or offering them the seat when you see them, there is no law which mandates that. Likewise, when you go to a friend's house or a relative's house, removing your footwear while entering the house, there is no law which mandates that. Likewise, while in the virtual field or in the cyberspace, we may have to subscribe to certain behavioral protocol, like the forwards that we used to receive, wherein it is stated that if you got a problem, face it, don't Facebook it. Likewise, whenever you post with discernment. One of the benchmarks or criteria would be never put anything in the net or in the cyberspace which you won't like to be seen in the front page of the newspaper next day. Now, let us come to the final aspect before I conclude. That is regarding management. The management, I would say, number one is just like saying ragging. How does ragging increase? Ragging in colleges and institutions increase when you don't complain. Here, the first protocol is whenever there is a defamatory remark or something objectionable regarding you, or if you notice it, immediately you will have to report. Then you'll have to move ahead. For which some provisions that require attention would be section 67C. That's again regarding intermediaries, but still 67C says preservation and retention of information by the intermediaries. One thing, let us make it very clear that unlike any other crime scene in actual world, which could be manipulated and destroyed, anything that is posted in cyberspace remains there. A cyber sleuth with the right tools, it is a sterile environment. No, there is no impurities. There is no way it will get erased or disappear. So whenever you do something, just because you delete in your system, or even if you burn or destroy your computer, the cyber traces will be there. And with the cyber sleuth, with the correct tools, can definitely find out that such and such thing has been posted from such and such a computer source. And if you are the person in charge of that computer or computer resource, then you will be held liable and responsible. Now, 67C says preservation and retention of information by intermediaries. Intermediaries shall preserve and retain such information as may be specified for such duration and in such manner and format as the central government may prescribe. Any intermediary who intentionally or knowingly contravenes the provisions of subsection 1 shall be punished with an imprisonment for a term which may extend to 3 years and also be liable to fine. So there is a liability cast on the intermediary to preserve these materials so that proper adjudication can be done. Now, few things regarding management. Blocking. Let us first see how you can block, or how you can, it is known as that universal takedown, etc. thing. Initially, there was a rule that is dated 7/7/2003. That is, the rule is the Order on Procedure for Blocking of Websites, GSR 529E, dated 7/7/2003. Powers were given to CERT-In, that is Computer Emergency Response Team of India. But after the amendment in 2009, by virtue of Act 10 of 2009, which came into effect from 27/10/2009, the powers of CERT, or Computer Emergency Response Team of India, has been delineated and specifically stated in section 70B. The earlier order was on the basis that there is no special or specific provision for blocking, but section 69A was also added. 69A empowers blocking, 70B states the powers of CERT-In, and in 70B and the rules regarding the powers of CERT, there is nothing. That is the information technology, the Indian Computer Emergency Response Team, and manner and performance of functions, duties, rules 2013 does not empower them. So what is the procedure? So to manage a situation, how do you go about it? Let us first see section 69A. Section 69A of the Information Technology Act. Power to issue directions for blocking for public access of any information through any computer resource, where the government or any of its officers specifically by it in this behalf is satisfied that it is necessary or expedient so to do in the interest of sovereignty and integrity of India, defense of India, security of the state, friendly relations with foreign states, or public order, or the prevention of incitement to the commission of any cognizable offense relating to above, it may subject to the provisions of subsection 2 for reasons to be recorded in writing by order direct any agency of the government or intermediary to block for access by the public or cause to be blocked for access by public any information generated, transmitted, received, stored, or hosted in any computer resource. The procedure and safeguards subject to which such blocking for access by the public may be carried out shall be as may be prescribed. And following the prescription, rules are made, or rather, the Information Technology Procedure and Safeguards for Blocking for Access of Information by Public Rules 2009. GSR 781E dated 27/10/2009. There are different things stated therein, but for us, what is relevant is Rule 9 and 10. Blocking of information in case of emergency. Well, Rule 10, process of order of court for blocking of information. In case of an order from a competent court in India for blocking of any information or part thereof generated, transmitted, received, stored, or hosted in a computer resource, the designated officer shall immediately, on receipt of certified copy of the court order, submit it to the Secretary, Department of Information Technology, and initiate action as directed by the court. So, the procedure that has to be adopted if there is an objectionable content is to approach the concerned civil court, competent concerned civil court, obtain an order of injunction, and comply with Rule 10 and get the objectionable thing. And the classic case, as you all know, is that of Baba Ramdev. That is Swami Ramdev and others versus Facebook Incorporated and others. That is of the Delhi High Court. The citation would be 263 in bracket 2019 DLT 689. A very, very elaborate and long judgment, but a wonderful judgment, I would say. 263 2019 DLT 683 or 2019 bracket 178 DRJ 151. Here, the order was given for universal takedown of defamatory materials that were in the site, because already it was found that it was defamatory by the court, and it was posted, and the court overruling all the objections. Now it's before the division bench. I don't know what is going to be the fate of this decision, but still, as far as we are concerned, as of now, this Swami Ramdev and others versus Facebook Incorporated and others, it is a literature in itself. If you go through it, it is, I'll just, a couple of things which I can say about that decision is, the court held that once content was uploaded from India and was made available globally, the removal of such content, once ordered by a competent court, shall also be worldwide and not just restricted to India. The Facebook Incorporated and others contended that geo-blocking is sufficient, geographical area, India alone. The court held no, it is to be global. The court ordered the intermediaries to take down the content, that is the defamatory videos, globally if they were uploaded from India. For uploads from outside India, the court ordered platforms to ensure that they use appropriate geo-blocking measures so that users from Indian IP addresses were unable to access the content. The court allowed Baba Ramdev and Patanjali Ayurveda to notify the platform, notice and takedown mechanism, in case offending material was discovered by them in the future, for takedown either from India or globally, depending on from where the content was uploaded. In cases where the platforms disagreed, they could intimate their disapproval, after which the complaints would need to take recourse to courts. The crux of the reasoning lies in section 79(3), I read out earlier. With the definition of computer resource, computer system, and computer network as per the IT Act, the court explained that according to the said provision, intermediaries were obligated to remove content from their platform once ordered by a competent court. Such content was to be removed from the computer resource controlled by the intermediary. Since the definition of computer resource included within its ambit a computer network, which wasn't merely a single computer but encompassed a maze or a network of computers akin to global computer network, the content must be taken off globally. Another reasoning which the court relied on was that since the defamatory content, though it was uploaded from India, was available throughout the world and thus once held to be illegal, must be taken off globally. The court held that, again, any other interpretation would not give full effect to the intent of the Information Technology Act or the judgment of the Supreme Court in Shreya Singhal. Reiterating the principle upheld in Shreya Singhal, the court recognized the intermediaries shall not apply their own mind as to whether certain information should be blocked from the platform or not. Once a court order is received, they cannot sit in judgment. It has to be complied with. As soon as certain content was uploaded from India and was made available globally, Indian courts attained jurisdiction. for such content to be removed, not just from Indian domains, but globally. Based on an interpretation of Section 75 of the IT Act, which provides for extra, that is what I said, 1, 2, and 75, which I read earlier. The court held that if content was uploaded from India or was located in India can be accessed in India, Indian courts could have jurisdiction to pass global injunction. So that is where it is not written in 75 as an Indian by any person. That is the wording in Section 75. On the question of technical feasibility of blocking content worldwide, the court relied on the reasoning that platforms took down information globally when their community guidelines were violated, thus having capability to enforce a takedown. So it was no defense saying that we can. And whenever you want, you are doing it, use the same technology, obey the court order, take it down. The court stated that once removal was ordered, it needed to be complete and not partial in nature. Geo-blocking could be easily circumnavigated by using VPN services, thus rendering the protection given to the aggrieved incomplete. The court reasoned that it needed to strike a balance between the right to free speech and expression and the right to privacy of the aggrieved party in this instance, right to reputation, national security, and threats to sovereignty. So, going by the decision rendered by the Delhi High Court, if it can be accessed from India, if it is uploaded from India, and you got a complaint, you can definitely get an order, and that order, if communicated to that platform, intermediary for that matter, it has to be taken down, and no geo-blocking, etc., which as contended by the would be of any consequence. Now, one another point that is vexed, and in our platform also we had a deliberation and discussion, was regarding how or who will certify this digital evidence or computer evidence. We have Section 45 of the Evidence Act, which deals with expert evidence. But after the incorporation of two provisions, that is Section 79A in the Information Technology Act and Section 45A in the Evidence Act, is it not the examiner of electronic evidence alone who is entitled to examine or authenticate the evidence that you will be, whether it is defamation or whatever it may be, if you want to rely on that. I'm not on Section 65B certification. I'm talking about authentication by way of an expert. Regarding which, I just two aspects. That is, there was a that is Ministry of Electronic and Information Ministry Technology, that's MeitY. Now, from we have, as you all know, Act is of 2020. We are 2010. We are in 2020, and this Section 79A was incorporated in 2009. We are again in 2020. All these years, nothing happened. For the first time, we have this labs. Examiner of electronic evidence notified starting from March 2018. I'll just read out the 7 labs as on today that has been notified. And prior to that, I would say the Apex Code had an occasion when there was no notified labs. What is to be done? There is an order you will find dated 24/10/2016 in State of Orissa versus Jayanta Kumar Das. I got only the Manu citation, that is Manu/SCOR/37376/2016, wherein reference is made to Section 45 alone, not 45A. 45A, why not? Because as you all know, 45A directly relates to 79A. 79A, there was no notification at that point of time. So there was no point in referring to 79A. So the court held that under Section 293 CRPC, reports of government scientific experts, that could be had. And we have a notification of 2013, wherein we have 6 labs notified. Out of which lab number 5, that is Central Forensic Science Laboratory, Hyderabad, is alone retained in the present notification. I'll just read out the 7 labs that has been notified under Section 79A. Number 1, it's not in the way any particular order, but still, Regional Forensic Science Laboratory, Northern Range, Dharmashala, Himachal Pradesh. Cyber Forensic Laboratory, Army Cyber Group, DGMO, Signals Enclave, New Delhi. State Forensic Science Laboratory, Madiwala, Bangalore. Central Forensic Science Laboratory, CFSL, Hyderabad. It was there in the notification under section 293 CRPC as well. Directorate of Forensic Science, Gandhinagar, Gujarat. Computer Forensic and Data Mining Laboratory, CFDML, Serious Fraud Investigation Office, SFIO, Delhi. Then notification of Forensic Science Laboratory, Government of NCT, Rohini, New Delhi. These are the only things. So examiners of electronic evidence will be the only persons authorized to tell courts if an e-evidence is authentic, because of the principle of special governs the general. We shall have a deliberation on that. That is my take on that. So that is regarding section 70, section 79A and 45A. Then you can also compound the offences if necessary. That is provided under section 77A of Information Technology Act. A court of competent jurisdiction may compound offences other than offences for which the punishment for life or imprisonment for term exceeding 3 years has been provided under this act, provided that the court shall not compound such offence where the accused is by reason of his previous conviction liable to either enhanced punishment or a punishment of a different kind. Provided further that the court shall not compound any offence where such offences affect the socio-economic conditions of the country or has been committed against a child below the age of 18 years or a woman. If the person accused of an offence under this act may file an application for compounding in the court to which offence is pending for trial, and the provisions of section 265B and 265C of the Code of Criminal Procedure shall apply. That is as far as compounding is. And as far as the law is concerned, as you all know, that the approach of US and UK laws are different. For that matter, defamation laws, UK onus is on the defendant to show that the content is not defamatory, whereas US onus of proof is on the plaintiff, heavily lies on the plaintiff. Now, the global injunction order that was granted also invoked Article 244 and 246 of the Indian Constitution. That's for your reference. Baba Ramdev case can be taken to be a locus classicus regarding global blocking and geo blocking. Now, one word regarding jurisdiction, because the regular law applies. I just refer to the decision of the High Court of Australia, that is in Dow Jones and Company Incorporated versus Gutnick, that is 2002 HCA 56. The court held publication of a defamatory statement is a bilateral act in which the publisher makes it available and a third party has it available for his or her comprehension. Therefore, the article was published. Therefore, the article was published with respect to Gutnick's cause of action, not when Don Jones placed it on its web server, but only when the subscribers in Victoria accessed it. The site recorded about such and such hits. People from Australian credit. It was not ascertainable how many of these were users from Victoria. Then finally, the court concluded for centuries that the law in defamation cases has been that publication takes place when and where the contents of the publication, oral or spoken, are seen and heard and comprehended by the reader or hearer. Having decided that a person is defamed in the place where having decided that a person is defamed at the place where publication is made, the court found that the dissemination of the material on the internet and the downloading of the information in Victoria meant that publication had been made there. Then again, this in fact is an affirmation of the Victorian Supreme Court decision in Joseph Gutnick versus Don Jones and Company, where Justice Hedigan held that publication of an online article occurred in the jurisdiction where the article was downloaded, regardless of where it was uploaded or where the publisher's server resided. subscribers downloaded and paid for the article through a Victorian web browser, and the meaning of the article was conveyed to the reader in Victoria. For these reasons, plaintiff succeeded in establishing that Victoria was the relevant jurisdiction. For this, that a person is defamed at a place where publication is made, and in the context of internet, it is downloading of the information that is relevant fact for identifying the jurisdiction. So I would say that this may encourage forum shopping also. We will have to look into it openly. Now let us come to Indian scenario. See, in Bennett Coleman and Company versus Union of India, that is 1972 to SEC 788 or AAR 1973 Supreme Court 106, it was held. Publication means dissemination and circulation. That is, communicating defamatory statements only to the person defamed is not publication. In Balraj Khanna versus Motiram, that is AAR 1971 Supreme Court 1389 or 1971 3 SEC 399. It will be highly desirable, no doubt, if the actual words stated to have been used by an accused and which are all to be defamatory are reproduced by the complainant. The actual words used or the statements made may be reproduced verbatim by the complainant if the words are few and the statement is very brief. But in cases where the words spoken are too many or the statements made are too long, it will be the height of technicality to insist that the actual words and the entire statement should be produced verbatim. As far as cyber defamation is concerned, there are tools, ways, and means of getting either the what I can say screenshot or a replica or ways and means of having it replicated and reproduced, and procurement, preservation, analysis, and production or presentation before a court is possible. Then I'll also refer to one word from Shreya Singhal's case, wherein even though it was dealing with 66A, it will be noticed that for something to be defamatory, injury to reputation is a basic ingredient. Section 66A does not concern itself with injury to reputation. Something may be grossly offensive and may annoy or be inconvenient to somebody without at all affecting his reputation. It is clear therefore, that the section is not aimed at defamatory statements at all. So I can make a bold statement that Information Technology Act did not contain any provision dealing with defamation per se. And that is regarding that. So let us draw a distinction between blocking and takedown. The provisions are different. Blocking is covered by 69A, whereas takedown is under 79(3). Now, let us, before I conclude, just I wanted to run through the steps that can be taken, because I was asked to give a practical guideline of how it has to be. As and when a defamatory statement comes, you will have to immediately take action, because I would say that I put it as act fast, because the internet is so wide, the damage can be, it can have a cascading effect, it is global, etc. So as and when you see to that you report it immediately to the local police or to the cyber cell. And as far as Kerala is concerned, earlier you had to go all the way to the cyber cell to register a complaint. I'm sure that corresponding provisions will be there in all other states also. Now any police station has to register the FIR. Then they'll have to forward it to the concerned cyber police cell. Then we have one important aspect which I wanted to mention was, now we have a national portal. It is known as National Cybercrime Portal. Through that link, you can directly register the complaint. That is, you just need in the Google type National Cybercrime Portal. You will get it, or otherwise it is https://cybercrime.gov.in. And another aspect you'll have to keep in mind, though maybe slight deviation might have been brought by two decisions, which I am not very sure to what extent they will be applicable. But cognizance can only be taken on a complaint. But a confusion was created in the sense like two decisions may be looked into, that is AAR 1997 Supreme Court 1 and 2012 Volume 6 SCC 353. When cognizable and non-cognizable offences are together, the police can, even in the absence of a complaint or a private complaint to the magistrate, can take action. This at times is being used or rather misused to initiate action in defamation. Otherwise, it can only be on a complaint and not otherwise. Now, to conclude, I would summarize my presentation in this manner. That is, free speech and expression is the soul of any democracy, or for that matter, it is highly necessary. But that does not give you a license. It is speech and expression, not to malign, not to defame, and it comes with reasonable restrictions. So there should be a balance between freedom of expression and reputation, or I would say respect for privacy. The Puttaswamy decision, all those decisions has to be looked into, wherein privacy has now been equated as a right, even though there is no special law regarding privacy as far as India is concerned. But still, the basic concern which I could discern from this entire exercise of doing my research for this presentation is, or rather taking classes in different forums, we were part of the PKI outreach program, that is Public Key Infrastructure Outreach Program of Government of India, that certifying authority, wherein we were trying to demystify cyber law and propagate digital signature. Is the lack of awareness of cyber ethics or social media ethics is one of the reasons. Then we may also have to simplify the procedure, because the procedure is complicated. Nobody is aware of how to do. If something is going, something has gone wrong, you don't know how to take the evidence, how to present, how to procure, where to go, and things like that. In the public domain, the government, as the state, has to take action to see to that these sort of information. It is just like Jago, that is regarding that consumer movement, wherein everybody is now being educated regarding consumer rights, etc. Likewise, these, because information technology or web-enabled technology or web-enabled services are going to be the in thing, and it is not going to disappear. And I think that will be the, especially in this pandemic time, etc., we are so much dependent upon this technology. So unless and until the correct cyber behavior protocol is made available and told to the public, or the general public understands it, there will be an issue. There should be a dedicated cyber cell and experts, and also counseling centers. Then there should be more international cooperation. Then strict implementation of the laws also should be there. And to conclude, I would say that the very purpose of the Information Technology Act was to support and to promote e-governance and e-commerce. It is not a punitive statute. That is why nowhere in the Information Technology Act you will find the term cybercrime. We have been indiscriminately using the term cybercrime, but in the Information Technology Act, nowhere is it used. I would say that thank you for your patience, and I'm sure that I just been able to touch upon the peripherals of the subject and trigger some thoughts. And if it does some, and one more decision which I thought not on the subject, which came across when I went through, it is State of Tamil Nadu versus Suhas Katti. It is of 2004. This is the first case that was categorized under Section 67 of the IT Act. That is by the Metropolitan Magistrate, Egmore, CC 4680/2004. If you put court of Suhas Katti case, you'll definitely get in the Google. It was decided on 5/11/2004. It's a very interesting read. So thank you very much for your patience, and thank you for the opportunity. Thank you.
Thank you. Since we have Mr. Prem, I will say today Prem will act more like a moderator, because people are saying that it's a combo of how do you pronounce littles or lightles? LETILS. Pardon?
Littles.
Littles. Yeah.
Littles. LETILS. Legal empowerment through
No,
interaction.
I understand that. I've
Yeah.
been following that. So I will ask. One, they are asking that the kindly share the judgments. So kindly share the judgments. I will post it in the WhatsApp group.
Okay.
This is by almost all people use social media and platforms like Facebook, Twitter, etc. Most of the lady journalists face and abuse defamation in these platforms. Is there any format to prevent such defamatory state? That
Because I'll just answer in this manner, because we have an update. If you can see, effective from October 1, 2020, section 3.2 of the terms of service of Google, Facebook, they have said that we also can remove or restrict access to your content, services, or information if we determine that doing so is reasonably necessary to avoid or mitigate adverse legal or regulatory impacts to Facebook. So every platform has got now an inbuilt mechanism. So you can directly apply to that for one thing. And otherwise, if at all, if you feel it is defamatory and derogatory, the regular pattern is that file a complaint before the cyber cell. Number one, file a suit for injunction. Once you get the injunction order, complying with the Rule 10, you'll have to transmit it for blocking that. And to prevent, I don't know, because somebody perpetrating crime, how do you prevent somebody from doing it? But there are safeguards to be taken. You don't post things which you don't intend others to know, because usually when we operate this internet or when you're on the internet, our guards will be down. Either you will be in your bedroom or you will be in the privacy of your room, wherein do things which I would say the easiest way is that do only those things which you would do in the actual world, in the cyber world as well. Will you do in the actual world running around showing thumbs up, or will you ask somebody or nobody you are not even seen, or in your entire life that I had coffee today, it had one more cup of sugar in it, or something like that? The way you post, it is not intended to anybody. It is open to the universe. Would you do it in the actual world? If you don't do it in the virtual world also.
So this is by Praveen. This probably will deal with that other aspect also by Dr. Srinivas. How to prove all these electronic communications and what is its evidentiary value?
That if you'll have to start from everything, I'll just put it in this nutshell. Number one is that evidence should not be compromised. Forget about what do you think of digital evidence? Just think of an NDPS case. Just think of any other case wherein you require an evidence to be analyzed and then produced in a court of law. The chain should not be broken. The procurement should be proper. The analysis should be proper. The presentation should be proper. So in the actual world, what all questions are available, there are corresponding provisions or ways and means and technologies available in the virtual world also. Take care of that. Only issue is that after the recent clarification given by the 3-judge bench, Section 65B certification is mandatory if it's not the original that you are producing. Then regarding authentication or rather testing, I believe that after these two provisions of 79A and 45A, it is only the examiner of electronic evidence who can do that.
Is it necessary to examine the expert witness in case mobile phone got tested by a private forensic lab and test reports have been exhibited in a defamation case?
That is earlier the position was that section 45, for example, can you say that a carpenter is not an expert under section 45B if something to do with carpentry? Was the expert is only a person who has have the experience, knowledge, etc. It's not a certificate given by anybody. If it is recognized in that community, it is right. But once a special provision has been enacted, when it is specifically stated by way of 45A reading into it 79A, and the government now coming out with 7 agencies, I believe that this private, now at least after 2018, it may not be legally admissible, is my take on that, subject to what this August Assembly would like to say.
This is by Arun Wani. Is it possible to connect personal CCTVs to internet? If yes, then will it help to retrieve the data from the service provider, even if the individual CCTV is deleted? This is not with the legal aspect.
That's technology.
Yeah, that's technology. This is by Dilip Kumar Selvarajan from Madurai. He says, wife was driven out from the matrimonial house after a child was born. When the marriage is in subsistence, all of a sudden in-laws as a paid member searched bride through a popular matrimonial site stating his son is divorced and no child. More than 200 profiles had been viewed and requests had been interchanged. By this advertisement / profile, the dignity of the wife as well child was questioned. Will it amount to cyber defamation for a child and a wife?
Definitely, if we can show, you forget about cyber defamation. Had he published in a newspaper, will it amount to defamation? Just answer that. If the answer is yes, then let us not confuse issues, because let us not think of the technology. Just take it out of the cyber context and keep it in the actual context. If it amount, because for cyber defamation there is no special law. It is only again 499, 500, nothing else. So if a married man with wife and child publishes in the newspaper that he is a bachelor and he would like to get married, that would cast aspersions on this wife and child that they are illegitimate or paramour or something like that. If you are able to prove and establish that, maybe a defamation, if in the actual word would definitely lie in virtual word also.
This is political satires, cartoons, caricaturing political parties and leaders, hate speeches. Do they tantamount to defamation?
That is where I said about Sullivan's case, wherein there should be actual malice, because public figures and politicians are running a risk when they become public figures of this sort of basic criticism and things like that. That need not and may not, unless and until the boundaries are properly kept, amount to defamation per se.
I don't think there are any questions on the platform. Till Mr. Prem gives his insight, I'll just check it on the Facebook. Yes, this is on the Facebook. If an accused posts a defamatory video on a YouTube and later on deletes it before it is led and proved as an evidence, then how can that be preserved and proved?
Cyber traces, I am told by SIDAC, and we had in 2 cases wherein the entire thing was deleted. It was able to be traced back, and there will be cyber traces of everything, and it can be recreated, because there is no way by deleting it is lost in the cyberspace. It remains. Only thing is that it requires the right tools and the expert to take it out. It can be done. Once posted, it never disappears.
This is by engineer Abhishek Sharma, who is into cyber forensic research and practice. What about the shareholders and CEOs of a multinational through blockchain technology, which can have digital signatures? Should their footprints be tracked by government cyber forensic sciences so that it becomes taxable?
I did not get the question.
Yeah. Did you? Was it audible?
No, your sound was breaking. I could not get it. What was the question?
Yeah. It says, what about the shareholders and CEOs of a multinational companies might be using private keys for international payments through blockchain technology, which can have digital signatures? Should their footprints be tracked by the government cyber forensics so that they make it taxable?
Oh, that again has got nothing to do with defamation. That, of course, I mean, I'm not very sure about that, because that does not cover the subject today. But of course, if there is a criminal element or evasion of tax, the government is at liberty. There can block, intercept. Provisions are there in the Information Technology Act, even to the controller of to intercept and take action, or whatever it is. There is. It can be, if the government really wants to.
before we conclude for the day, I will ask Prem to wrap it up in his own style, because he has his own style, raising his hands and rocking his chair. I will ask him to do that. Yeah,
Prem, don't forget to do those two things.
Well,
because when he came on the platform, people were all gaga about his knowledge, that he could speak off the cuff all the judgments. And in fact, I also found that.
For us, he is the mobile encyclopedia.
Probably we took the topic, taking cue from that.
well, let me first ask you, the judgment of Justice Swaminathan, is it that case of Sandhya Ravi Shankar, which you referred to?
Yes.
Okay. So in that particular case, taking note of exceptions 2 and 3 of 499 and applying the Sullivan's rule, which of course is applicable in the states of America, it was quashed. But let me ask you one question. Just in that particular judgment, because exceptions to section 499, it can be taken note of, or rather it can be considered only at the stage of trial. Now you have 2 3-judge benches which stare at you. One is Sevakram's case, which is 81-3 SEC 208, and the other is Shatrughan Prasad Sinha versus that Rajbhanu Rati and others, which is 1996 SEC 263. Because it could be taken care of only at the stage of trial. Won't it run counter to these 2 Supreme Court judgments? Because both the cases, the Supreme Court went on to say that the High Courts committed a manifest error in quashing the criminal proceedings, exercising the jurisdiction under section 482 of the CRPC, taking into account the exceptions which are laid out. Of course, Sullivan's rule, that's applicable to US state of, the United States of America, where you don't have this particular view by any of the judges. The other view is otherwise. Won't this particular judgment of Justice Swaminathan run against these 2 particular Supreme Court judgments?
I can only answer in this manner, because Justice Swaminathan himself takes note of that, and he states that
he goes on to say summary examination.
Correct. And after that, he adds one line that would clarify that, because he would say such an activist role will have to be played by the higher judiciary, because it is a matter of record that criminal defamation proceedings have become a tool of intimidation. Here, he reads 482's last one. That is, prevent abuse of the process of any court or otherwise to secure the ends of justice. So, under this code, nothing in this code shall be deemed to limit or affect the inherent power of the High Court to make such orders as may be necessary to give effect to or to any order under this code, 1, or to prevent abuse of the process of any court, or otherwise to secure the ends of justice. He interpreted, but of course, the larger bench decisions of the Apex Court or the Apex Court rulings would be glaring, but the circumstances may be able to, because if it was able to be clearly established that it would be an indulgence in luxury, the trial itself, maybe it was justified. I'm not passing anything, any comments on that, but of course, there are decisions which says that 482 be used very sparingly, and if something is to be left to trial, it has to be left to trial. But on the face of it, it was able to be shown that it comes under the exceptions under 499. That is how it was decided, I believe.
Okay, and now, even with regard to the cyber defamation also, it's not exactly the cyber defamation which I am adverting to. Because in the Hamlin lectures of 1949, which was a lecture which was given by Lord Denning during 1949, and you have these words of Lord Denning in some of the Supreme Court judgments, like you have Kishorilal Minochia's case, you have the Bhagalpur blinding case, Khatri 2, then you have Rudal Shah's case, etc. Now, and even the Meerut fire tragedy case. Now, don't you think, suppose if defamation is again mixed with another cognizable matter, won't it short circuit section 198 of the CRPC? Of course, there are Supreme Court judgments during 1997, as you have put in page number 1, and the 2001 judgment, which would say, if you mix up, of course, the police, there is nothing wrong. But as far as defamation is concerned, won't that short circuit section 198 CRPC? Because 195 itself.
Will it short circuit?
Section 198 CRPC, because defamation, it has to be only by means of a complaint. Only
Correct.
by means of a complaint.
Correct.
Why such a thing has been placed? Because defamation falls under 19 clause 2. Again,
Correct.
that is also highly debatable, because whether 19 clause 2 defamation constitutes defamation, taxing a person with a criminal liability, that the Supreme Court has not considered in Subramanian Swamy. It is
Correct.
to be considered in the Kaushal Kishore's case, which we are yet to see the judgment. The judgment has not come. Now, won't that short circuit Section 198 CRPC? Why? Because Section 198 by itself, even though procedural, it lays down some sort of substantive law that only the person who has been defamed. Of course, the exception is for the public personalities.
If I can forget these two Supreme Court rulings, and if my personal opinion is sought, I would fully agree with you.
Anyway, it was a very wonderful lecture, a very wonderful talk. We got a lot of learning, and it was an erudite and enlightening kind of talk. Thank you so much, and that is wonderful, absolutely wonderful.
Thank you, Prem, for your kind words. I hope you do really mean it.
I really mean it.
Thank you, Vikas. Vikas, you'll have to unmute.
No, I am saying that actually what we say, they'll say, Prem was saying they'll say that the session was very enlightening, plus your erudite talk on the aspects. And it's one of the facets which you don't find much of the law. It's just evolving, and every time we are doing that. And tomorrow we would be having a webinar just like what we had today, those who are holding a webinars. We have senior advocate from Madras, Mr. Om Prakash Atlante. He will be speaking on right of redemption, march of law. So do stay connected with us tomorrow at 4 p.m. We are quite sure that the webinar, as usual, would be quite knowledgeful. And thank you to Shyam Padman to give the insights, and also to Mr. Prem Raj, as he said that in the last minute we asked him to give the opening shot and the last shot. But they say in cricket, the one who plays the first shot and the last shot are the most memorable moments. So Prem has his own moments to enjoy from this webinar. The way we enjoyed the entire webinar with the knowledge insights being given by Shyam and the right pitches from Prem. Thank you, everyone. Stay safe, stay blessed, and tomorrow we will connect at 4 p.m. Namaskar.
Thank you. Thank you.
Thank you so much.